Mr. Adil Hassan, there's now no doubt about it. The Hindu side is vindicated. It has a right to investigate the character of the structure that we are seeing, whether it was actually built by force on a temple or not. A scientific inquiry is being conducted. And I want to ask you now, sir, very simply, fundamental question. Why are you opposing a scientific inquiry which will get to the truth? Are you afraid of the truth, sir?
बड़े भाई, nobody is afraid of the truth. The reality is that 1968 में जब आप दोनों पक्षों के बीच समझौता हो गया था, जब दोनों पक्ष तैयार हो गए थे, 50-55 साल बाद ऐसी क्या बात होगी तो आप इस चीज का मामला आप उठा रहे हैं? आप ही खुद बताइए, ऐसा क्या मामला जब दोनों पक्ष जो बड़े बुजुर्ग ने समझौता किया था तो देश ने माना था, उत्तर प्रदेश ने माना था?
नहीं,
ऐसा तो नहीं है कि हिंदू
आदिल हसन साहब, आज की डेट में ये आप रेटरिकल सवाल नहीं कर सकते, क्योंकि कोर्ट ने तमाम आर्ग्यूमेंट्स को मद्देनजर ये फैसला सुनाया है. द कोर्ट इन ऑल इट्स विजडम, आर यू डाउटिंग द कोर्ट्स विजडम?
मेरा ये कहना है, हमारा साफ कहना है, 9 जनवरी को सुप्रीम कोर्ट में मामला था, तो इतनी हड़बड़ी क्या थी? ऐसा कौन पहाड़ टूट रहा था जब हिंदू और मुसलमान?
तो आप ये नहीं समझते कि कोर्ट ये सब आर्ग्यूमेंट्स कोर्ट ने क्या नकार दी क्या? आप ये कह रहे हैं? एक मिनट, जस्ट 1 minute. Let us get a legal opinion on this. 1 minute, open this up. Let's get a legal opinion. 1 second, sir. Let's get a reasonable. आप rhetorical बात करेंगे. J. Deepak will talk facts. First of all, what is your takeaway, Mr. J. Deepak, of what the court has ruled today?
See, one of the things that people haven't actually made sense of is the basis of the filing of the suit with respect to the Gyanvapi Mosque. And Vishnu, who's a good friend, has actually done his homework. He's read through the Place of Worship Act properly. And I think as is available under Section 4.3, to the best of my memory, of the Places of Worship Act. Because it basically says that if you're able to prove that any structure or any place of worship, so to speak, its antiquity is over 100 years, or it is treated as a heritage structure within the meaning of the 1958 Antiquities legislation or the archaeological legislation, then the provisions of the Act or the bar under the Places of Worship Act shall not apply. Okay, so that is the fundamental basis of the suit. Now, once you're able to establish, and you'll be able to establish only when you actually get a survey done, and therefore a survey is a precursor to the establishment of that fact under the provision of the Places of Worship Act. That's the first step. So there can't be an objection to the appointment of any advocate commissioner or any commission to undertake an archaeological survey of the area in question. That's point number 1. Point number 2, once you establish this, or even if there's a prima facie case established, then it is possible, rightly so under the legislation, to seek the right to worship for Hindus as well, or rather primarily for Hindus, because once you're able to establish that this was a place that has been claimed and we are trying to reclaim that the place, so to speak, then the bar under the Places of Worship Act, that you cannot change the character of the place, its religious character, so on and so forth, none of those bars would apply. Okay, so what the High Court has done is to first respect the trial process, which is that all your arguments you will raise before the court of first instance, which is the trial court. Go back and fight there. And 2, the validity of the prayers, the legitimacy of the prayers, all of them will be tested by the trial court. So in this matter, if you notice, the number of times this matter has gone to the Allahabad High Court and then the Supreme Court, it's almost as if every order that's passed by the trial court is the subject of an appeal, only to be repeatedly told by the higher fora that respect the trial process. Let there be a final decision that's taken by the trial court before the appellate court looks at it or before the Supreme Court looks at it. So I think the message that's gone to the defendants in the matter or the opponents of the plaintiffs in the matter is, do not take the system for a ride and do not try to circumvent the process of trial in the first place.
Do not take the system for a ride, Hassan Sahab. आज कोर्ट ने आपको ये क्लियरली बता दिया है. अब ये सब वॉट अबाउटरी बंद कीजिए और सीधा सच्चाई की तरफ बढ़िए और वो सच्चाई, that truth can only come out through a scientific inquiry. What is your problem with somebody determining the character of this place?
राहुल साहब, आप ही बताइए, 1947 में जो भारत के संविधान निर्माता डॉक्टर बाबा साहब अंबेडकर हो, सरदार पटेल हो, पंडित नेहरू हो, सब मिलके जो कहा था कि 1947 के वक्त में जो रिलीजियस स्ट्रक्चर था वो उसी तरह रहेगा।
अरे वो उस टाइम नहीं कहा था उन्होंने, 1991 में ये लॉ आया। प्लीज जानने तो जाइए भैया,
लॉ 91 में आया, लेकिन 1947
नहीं, किसी ने कहा सर, नहीं, सोमनाथ का रिकंस्ट्रक्शन हुआ था 1940, नहीं, राजेंद्र प्रसाद साहब खुद गए थे इनॉग्रेट करने। आपको कुछ हिस्ट्री ज्योग्राफी पता ही नहीं है।
लेट मी स्पीक। अरे सब पता है,
आप गलत बात है,
क्या बीजेपी का जैसे आप ही को आता है क्या सब?
देखिए, आप ऐसे मत बोलिए,
नहीं,
आप गलत बात कह रहे हैं, आप लोगों को भड़का रहे हैं, भड़का रहे हैं।
No, let me speak. No, let me speak.
No, you need to
no,
speak.
Let me speak.
Come
let me
clear.
Speak. You can't interrupt like
come
this.
Clear.
No, you can't interrupt like that.
How?
No, if you want to discuss on BJP agenda, then
Mr. Hassan,
no, it's
the
the way you
courts
are
are
putting
not. The
your
courts
words on
are
my
not.
mouth.
Okay, see, viewers, when people don't have enough to say, when they don't know what to say,
I am ready to,
they
I
will
am
start
ready to
attacking
answer.
people.
I am ready to answer.
They will
no,
start.
You don't
they
put
will
BJP
start,
agenda on me.
No, there's no BJP.
I know your agenda. I know your agenda.
Yes,
Please,
absolutely. Now,
don't put BJP agenda on me. My point is clear. My point is clear.
Listen, I'm not going to give space to you if you keep calling. No, if you're going to constantly impugn people.
Okay,
that's not the way.
I will not join your program.
You need to be factual, Mr. Adil Hassan.
Be happy with your program.
रोइए मत sir. Take an informed view.
You can't dictate your terms.
Don't become petulant. Take an informed view, Mr. Adil Hassan. I'm asking you a simple question.
I know.
What is the problem in determining, one second, the Places of Worship Act 1991 only prevents the conversion of a place. It does not, and no one is here converting the place. It only very pointedly talks about somebody who wants to convert a place. No one is converting the place. All the petitioners on the Hindu side are asking is to determine whether this is a masjid or whether this masjid was fraudulently built upon a temple. इसमें क्या हर्ज है?
अच्छा, what about 1968 agreement then?
Sir, that was between the wrong parties. The court has gone into this and it has nothing to do with, you are talking about the merits of the case. They will be looked at later. Okay, 1 minute. Let me bring in, okay, on this point, let me bring in, on this point, let me bring in Jaisai Deepak. Okay, he's not a BJP man. I'll ask him. See, the claim by Mr. Hassan is simple, that the Places of Worship Act 1991 still stands in the way of reclaiming the places of worship. Have the courts, in your opinion, done enough to resolve this, or is there more to be done?